On behalf of Disability Rights Florida, I'd like to welcome you to today's webinar. My name is Sylvia Smith, and I'll be moderating today's session. Before we introduce today's speakers, we would like to take a moment to tell you about Disability Rights Florida. Disability Rights Florida assists individuals with disabilities and their families to access education, employment, and greater independence. We provide free and confidential services such as information and referral, advocacy, legal representation, and help with negotiations. We also conduct investigations and monitoring in facilities where people with disabilities reside and receive care and services. We advocate at the legislature and with state agencies to improve Florida's laws, policies, and practices. And we work to eliminate abuse and neglect, especially in schools and facilities. A good companion resource to this webinar is our 9-minute video called 10 Steps to Effective Self-Advocacy. You may find the 10 Steps video on our website and YouTube channel. We encourage you to watch or listen to 10 Steps to Effective Self-Advocacy, even if you're a seasoned pro. We also urge you to visit the resources section of our website to access additional information and videos about your rights and responsibilities as a person with disabilities, a family member, a friend, a helper, a service provider, or other. We address disability topics such as housing, Social Security, disaster and emergency planning, special education, and transition. At the end of this webinar, you will have the opportunity to tell us topics we should cover in our next webinar and on our website. Now, let's get started. If you need to access captioning for this webinar, please refer to your reminder email for the link to our live captioning service. The presentation portion of this webinar will last about 45 minutes. Then, until 2:30 p.m., our presenters will answer as many of your questions as they can. The webinar chat feature will be unavailable and your phone access muted. So send your questions in to us by email to webinar@disabilityrightsflorida.org. You can send questions anytime during the webinar. The email will be monitored by myself throughout the entire webinar. Because this webinar is a public forum, we won't be offering specific individual legal advice during the webinar or during the question and answer period. But we will answer as many questions as we can and in as much detail as we can. You may always call us for additional information or specific advice about your situation. If you need additional information or specific advice about your situation, call us at 1-800-342-0823 or submit a request using our online intake system. We will repeat this contact information at the end of the webinar. Now let's introduce our presenters. My name is Sylvia Smith, and I will be your moderator today. I work as our Communications Director and one of 2 staff directors responsible for our legislative and public affairs work. I'm also an attorney with background in litigation and a graduate of Florida State University College of Law. Our presenters today are attorneys Edie Sheeks and Brian Funk. Edie Sheeks is a senior attorney who has been with us for almost 3 years. She's handled a variety of issues in her career and at Disability Rights Florida. She's currently involved in education and community matters as well as appellate and anti-discrimination practice areas. Edie Sheeks graduated from Florida State College of Law as well. Brian Funk is an attorney who has been with us for 4 years, starting as a legal intern. Brian Funk has significant experience in issues related to Medicaid and waiver services, administrative rulemaking, and vocational rehabilitation. Brian also graduated from Florida State University College of Law. With us today is also Keith Casaubon. Keith Casaubon is our Technology and Communications Manager. He's been with us for almost 11 years and previously worked for our sister agency in Louisiana. Keith has a master's degree in rehabilitation counseling and extensive training and experience in information technology. And we can't do our webinars without our IT guy. With that, I'll turn it over to Brian Funk, who will walk us through today's learning objectives.
Hello, everybody. My name is Brian Funk. Thank you, Sylvia, for those introductions. Much appreciated. I'm going to tell you all what our objectives are for today's webinar, just to give you an idea of what's to come. Our goal is that when you leave here today, or when you shut off this webinar, you'll be able to do the following things. First, we're going to list the 30 things to look for in an agency denial or reduction notice. We're also going to list the 5 basic steps of preparation for an administrative hearing. We're going to describe how hearings occur and how testimony is given. And possibly most importantly of all, we're going to state when you should begin preparing for your administrative appeal. And I'll give you a little hint early on. The correct answer to that is as soon as possible. With that said, and with our objective set, I'd like to turn it over to Edie to begin talking to you today.
One of the things that's critical in terms of this whole process that we're talking about is the notice that you will get from the agency. It should be in writing, and it should tell you exactly why they are denying your services or reducing services that you already have. And again, verbal notice is not enough. It should be in writing. It has to be in writing. Continue on to the next one, Keith, if you will. Okay, when you get your notice, first of all, big picture, this notice that you get is the template, if you will, to the entire process of challenging it. This notice should contain 3 things, 3 important things. It should tell you how much your services are going to be reduced or the complete denial of the services that you've requested. It should tell you specifically why the agency made the decision to reduce or deny your services. And it also should include in fairly extensive detail and very clearly written exactly what your appeal rights are and the process for appealing. So this notice, it's a template to everything that you do. It's critically important. Okay. And at this point, I also want to point out to all of you, if you're not already aware, that on our website, Disability Rights Florida, there is a resources tab. And in the resources tab, in addition to the video that Sylvia referenced earlier, there also is a shortened form of Advocacy 101, and then there is a link to the actual e-manual, Advocacy 101, and it's a 46-page manual that goes into great depth about all the things we're talking about today. I strongly advise you, after you've listened to this, and if you're going forward on an appeal, read that or print that or review that, because it has a lot of really helpful information. Brian, did you want to say something?
I did. I just wanted to emphasize that the agency has a legal obligation in federal law to provide the individual whose services are affected with adequate notice. So if you receive notice from your waiver support coordinator, for instance, just telling you orally that she's been told or she's received an email that your services are being cut, that isn't sufficient. Like Edie said, the notice provides the backbone for this entire appellate system. So it's very important that you receive an adequate notice. And if you feel that you haven't received an adequate notice, you ought to request one. And if none is forthcoming, that might be an issue you want to contact Disability Rights Florida regarding.
Thanks, Brian. And one other piece of this, it's really important. This is the stage that you begin creating your file. It's really, really important, if you're going to be successful in this, that you be organized from the beginning. So keeping copies of every bit of documentation you have about this, including this notice, which you'll want to keep on hand, obviously, because it's going to tell you a lot of what you do. But every document that you send or file, you want copies of, and you want in your organized file system. And as you go along in this process, you'll be grateful that you did.
Okay, so at this point you have a notice in your hand, you or the individual you're assisting. A notice explaining to you the what, why, when, and wheres of how this reduction is taking place and what is important to you. What's critical now is the next step of where we're going to move from receiving that notice. There is the most important thing you need to keep in mind at this point is that there are deadlines associated with this step. you're going to be requesting an appeal. And there are two deadlines that you may need to keep in mind. The first deadline is that you have 30 days to request an appeal. Past 30 days from the receipt of your notice, if you wait that long to request an appeal, the agency is not necessarily required to allow you to enter the appeals process, to give you a hearing. So if you wait past 30 days from having received your appeal, you may not be able to argue for these services. You may have lost that right. So it's critically important that you keep a record of your timelines and make sure that things are done certainly within that 30 days, and considering this additional timeline as well. If this was a pre-existing service, a service that the individual already had, then if they request the appeal within 10 days of receiving their notice, they're able to maintain that service going forward through the course of the appeal. I'm sure many of you who have gone through an appeal are familiar with this system. So it is critically important that those individuals who have an ongoing service also abide by that 10-day deadline along with the 30-day deadline, because it can be much more difficult to pursue that appeal if you've already lost the service or if your health and safety is already endangered. So get your appeal in within 10 days if a service is ongoing, so you can maintain that service through the process. And certainly, regardless of what your circumstances are, make sure that you request your appeal within 30 days. That is critically important. Now, the process of requesting an appeal should be relatively simple. The notice that you received, as Edie spoke to you about a couple of moments ago, will have instructions on how to request an appeal. Under the law, it's generally acceptable to request an appeal either orally, that is by mouth, by telling someone that you'd like to have an appeal, someone appropriate with the agency, or through a written form. I'm going to strongly suggest that if you are serious about filing this appeal, you do so through a written document. Not only does this give you a record of filing that appeal, but it also gives you a way to express your arguments and your disagreements with the agency early on. And it can help facilitate the settlement process if that ever becomes an issue. The notice oftentimes will have a form attached to it, which will include blanks for information, which can be used to request the appeal. It will guide you in supplying all the information you need to, and should contain a name and an address of whom the form should be either mailed or faxed or sent to. So that is probably the simplest and most appropriate way of doing it. As I said, if you do miss the 10-day deadline, don't panic. You still have the 30-day deadline to fall back on. So you still should request an appeal even if you can't continue your service. But try to do so as soon as possible. That's going to be an underlying theme here. Do everything you can as soon as possible because it should give you the best outcome. Also worth noting is that you should maintain a copy. If you submit a written request for the appeal, maintain a copy of that request. Put it in your file like Edie talked about. That's going to be another lesson that you need to learn today. Maintain copies of everything because you may need to use it. If there's some dispute as to when exactly you returned your request, that'll give you the ability to show them a written and dated copy to indicate that you did reply appropriately and that your services should be maintained or should be allowed to undertake the appeal. Next slide, Keith. Mm-hmm. Thank you. And I'm also going to talk to you a little bit here about some words that we're probably going to use that some of you may not be familiar with. And saying that, we may use some other words that you don't understand. If that's so, please send an email, as Sylvia discussed earlier, to our questions address, and we'll try and explain what those words mean. And frankly, knowing the vocabulary, the lingo of these administrative appeals may help you in the process. So if we say anything you don't understand, jot it down and shoot us an email, and we'll try and address that later on. But here are 4 critical words. First, petitioner. The easiest definition I can give for a petitioner is you. You are almost certainly going to be the petitioner in your appeal. You, the individual you work for, the individual you care for. The petitioner is the individual who is losing or seeing their services reduced, and the person who is applying or requesting the appeal. The respondent is the opposite party. The respondent in these cases is generally going to be the agency that is reducing those services, whether it be the Agency for Persons with Disabilities or the Agency for Healthcare Information, or Healthcare Administration. The respondent is going to be the party that made the decision that you are appealing. An exhibit is just an individual piece of evidence. That could be a picture, it could be a document, it could be a prescription, it could be any number of things. An exhibit is a single piece of evidence, and we'll discuss preparing and gathering that evidence in just a couple of moments. And finally, the hearing officer is, for lack of a better term, your judge. The hearing officer is an individual who works for the Office of Appeal Hearings, which is a division within the Department of Children and Family Services, who will adjudicate your appeal. It's the individual who will help you with procedural issues, guide the process along, and ultimately make a determination on whether or not the agency's decision should be upheld. And we're going to discuss in the hearing section all of the things that the hearing officer can help you with. With that said, let's get into the meat of things. Edie is going to talk to you a little bit about how to prepare for your hearing.
Edie, I'm going to ask you to just wait for a second and see if the beeping frequency will level off here a little bit, because I know that's a problem for our participants, and I'm not sure why we're still getting it, because the attendee list seems to have leveled off at about 205. But I want to make sure people can hear us, and if you're having any trouble hearing us, please email me at webinar@disabilityrightsflorida.org so that we can address that. I know we have everyone on the 1-800 number, a couple of participants who we're trying to access through computer who I've been emailing with. All right, I think I like the sounds of that a little better. Edie, take it away.
Okay. Thank you, Sylvia. Keith, next slide, please. So 5 steps of preparation is what should be in front of you now. And as Brian and I have just covered, the notice that you receive and the information you need to look and understand what's in that, those are the keys to how you begin and how you carry out your preparation for this hearing. So after you have gotten the notice of denial or reduction, and then you have timely filed, I hope, that means within the 10 days if possible, to appeal the reduction or denial. After you have filed that, then you should be getting a letter back from the Office of Appeal Hearings in response to that. This tells you when and where your hearing will be held. It's critically important information, and we're going to be talking more about that shortly. But first, let's talk about preparation. And again, you can't start too early. Once you get the notice, that's when you begin preparing for this. So when you first get the notice, and again, I can't say it too often, the notice of reduction or denial is the template, the outline for everything you do in terms of appealing this. So when it states in there exactly why the agency is reducing or terminating your services, you need to know on what grounds, where they're coming from on that. So the relevant case law and rules and regulations affecting your case, you need to be up to speed on those. One way to access it, and again, as I mentioned a few minutes ago, on our website, under Resources, the Advocacy 101 e-version of the manual. It's a 46-page manual. It has links in the back of it to all the places you need to go to get the agency websites, to go to the statutes, the rules, the regulations. You can find them all in there. In addition, within the text of that, it goes into detail about things to look for and understand when you're reading those. So first, start preparation. Understand what the guiding law is that the agency is operating under. You have the right and you need to know exactly what that is. Once you get that and understand that, then start drafting your response to that. They're saying you're denying your services because of this. Well, what is your reply to that? Why do you want to challenge that? Next slide, please. Once you have your answer outlined and what the draft of your response is going to be, then you start addressing how you're going to present that response to the hearing officer. And Brian, did you have a comment? So the first thing you do, you've got exactly what your responsive argument is going to be. So then start figuring out how you're going to document it, how you're going to prove it in the hearing. And even though all of us have spent much of our lives watching television and court cases, and we all have a sense we understand what happens in these kinds of things, don't go with that. It's very, very different from that. This is a very informal hearing. Even though in some of the best law dramas that we're all addicted to, the drama part of it is really critical. We don't want drama in these hearings. The hearing officer, no matter how dramatic the testimony or the presentation, the hearing officer is bound by the law. So you understand why the agency is denying your request for services or you're cutting your services. You've figured out what your response is going to be. You've gotten the law that governs it. The next thing is you have to get your evidence and your witnesses together to support these arguments. And we're going to talk more about witnesses and testimony shortly. And Brian has already defined evidence for you. It's basically documentation of any kind that supports your argument. Witnesses, in terms of choosing witnesses, think in terms of what your argument is and who would be best prepared to support your argument. Oftentimes, witnesses are treating physicians, therapists, caregivers of any kind, people who can attest to the validity of your arguments. And in terms of evidence and witnesses, oftentimes they overlap in that if there's a treating physician who you may want to testify at your hearing, you may also have from him, and let's hope you do, a written documentation from him saying what kind of services he's provided and what the necessity for those are. So you start getting all of those together, and again, paper trail. You want to document all that you're doing and who all you contact. Then you start preparing just rough draft formalizing what you're going to say at the hearing. You also have there's a necessity in a hearing like this for you to find out exactly what kind of evidence, witnesses, information the agency is going to be using in the hearing, what they're going to be relying on. You need to get this information as soon as you possibly can. Oftentimes, in administrative hearings like these, the agency prepares and sends out what they call a hearing packet, which covers all of the stuff that they're going to be using in your hearing. Don't rely on this. As soon as you get the notice of hearing, then referencing the case number that will be on that, you need to file a notice of discovery or request for discovery to the agency, and basically requesting, and you may do this informally, it just needs to be in writing, but requesting all of the information they have on your case, and they have to send that to you. And again, these topics are covered in considerably more detail in the Advocacy 101 manual.
Let's take a second to just summarize. This is a really crucial section. And before we do that, Brian, did you have something to add?
I did. Two things. First, as part of the discovery obligations that exist for this administrative hearing, the agency is obliged to send you any information they have that is relevant to the case. And like Edie said, you should absolutely request that. You are also obliged to send the agency information, and they may request it from you or they may not. Regardless, the goal of this hearing is for everyone to give all of the information they can so that the administrative law judge can make an informed choice. That said, don't try to hide any information. Don't expect to use a surprise tactic at the hearing. It may seem exciting or effective while you're preparing for it, but it's almost universally not going to be workable at hearing, and the hearing officer is going to strongly frown on pulling an argument out that has not been discussed beforehand. So be frank with the agency, be frank with everyone involved, make sure that everyone has copies of your evidence, and that should be effective for you.
Edie?
And just to add to that, and I'm certain Brian's assuming this, copies of it ahead of time. You want to, just like you would want to have all the agency's information concerning you ahead of time so that you can prepare a response, you also need to disclose and also let the hearing officer get most of the as much information as you have available to submit it well before the hearing date.
So we have a couple of questions on this topic that I thought it would be good to take now. And also, just to summarize, Keith, could you just take us back to where I just want to summarize, it's 5 steps. So back to slide 9. First of all, don't wait until the night before the hearing. And then we get into the 5 steps. If you're going in alone, or you're not an attorney, or if you are an attorney, you still have an obligation to find the laws and rules that affect the service and your case. And there are rules that govern when the agency must approve every service and every piece of equipment. Specific rules on durable medical equipment, specific rules on waiver services, specific rules on home health. And those are all linked and available on our website through the Advocacy 101 page. Second, start writing your arguments in advance. The earlier you start writing an outline of your arguments, the better. Slide 10. And then the last 3 steps, 5 critical steps, gathering documents and thinking about the people that you're going to want to speak on your behalf at the hearing. Then actually preparing with them what they need to say as well as what you need to say, and then requesting the documents that the agency has on your termination, denial, or reduction in advance. And what I hear you two saying is all 5 of these steps, it's not sequential, it's simultaneous. They've got to all simultaneously start as soon as you have notice of the reduction, denial, or termination. We received one question, which was, what if you don't receive that in writing? And I think your answer would be, start preparing, even if you only get it verbally, because it doesn't necessarily guarantee you more time just because you didn't get it in writing. But then you should put in writing a request for the denial, termination, or reduction in writing, because you're entitled to, and if we skip back just quickly, I think it's worth it before we move on to what the agency notice must include on slide 6. The agency notice must include 3 things, and you really can't, it's not fair for you to have to prepare for a hearing unless you've been officially notified of 3 things: the amount, the justification, and the process through which you appeal, your rights and responsibilities in the appeal. The problem with a verbal notice is it's probably lacking in one or all of those things, and you're entitled, before the judge adjudicates your objections to the reduction, denial, or termination, you're entitled to know exactly what the amount is, exactly what the justification and reasons are, and your procedural rights. So that's a good summary, I think, of these first 2 sections. Anybody have anything to add before we move on?
Yes, if I might finish in terms of the preparation. Slide 10, please, Keith. At the very bottom, the last section, if you need time to prepare, if you need more time to prepare, once you get the notice telling you when the hearing is, if you think you absolutely have to have more time to prepare, or the date that's chosen presents a serious conflict for you and you won't be able to attend it, then you have the right to request what legally is called a continuance, and that simply means that you're asking that the hearing be rescheduled for a later date. Again, as the chorus line throughout this whole presentation is do it early. As soon as you get the notice of hearing, check your calendar. Make sure that that date's available. Make sure that, given all that you know you're going to have to do to prepare by this point, you're going to have time to do it. If either one of those you think is going to need longer time, then draft or file a letter to the hearing officer, and you need to copy the agency also. And at this point, since you've got the notice, you have the case number. That's critical in all your correspondence. Put the case number on it, address the hearing officer, and the notice should tell you where to send it. And just file, it's called a motion for continuance. State your reason why the date doesn't work and ask that it be rescheduled.
We've gotten some really good questions on this section, but we're going to go through the hearing itself next and then try to wrap that up in the next 10 minutes, and then circle back to the many questions on discovery and preparation, as well as the questions we receive on the hearing itself. So please stay with us.
You've done your preparation, you've got your notice, and you are ready to go ahead and argue this in front of a hearing officer. The first question that is going to arise, and I know I get this question all the time with my clients, is whether or not they should have a hearing in person or via telephone. You as the petitioner, you or the person you're working with, has the ultimate say of whether or not the hearing is done via telephone or in person. Telephonic hearings might be more convenient. You don't have to travel. You can stay in your home. It might be easier if there are medical issues on the part of the individual. It presents some logistical advantages. On the other hand, arguing in person may make it a little easier for you to articulate your points because you can talk to the folks who are there. It may make it easier for you to stay organized. Ultimately, it really is a logistical decision. In my experience, and I think Edie will back me up on this, there isn't really a lot of practical difference in terms of improving your arguments between telephonic and in-person hearings. The judge, the ALJ, is ultimately, or hearing officer, excuse me, is ultimately going to make his determination based on legal issues, not who's wearing the nicest shirt or who came across better in person. So in terms of validity, either one of those options, telephonic or in person, is going to be pretty much equally effective. The real sense is which one is going to work better for you or for the individuals you have testifying. Another thing to keep in mind is that if you do an in-person hearing, you still can have certain witnesses call in to testify. That's especially popular with physicians and therapists, people who have busy schedules who may not be able to travel for the hearing. If you do have an in-person hearing, and that's most of what I'm going to be addressing, it's not going to be in a courtroom. This is not going to reflect the experience you see on Law & Order. There's not going to be a Jack McCoy at the front of the room banging on a podium. Instead, it's going to be like attending a meeting at your place of business. You're going to be in a conference room, most likely at a table with all the folks involved. You'll have an ALJ sitting at the head of the, hearing officer sitting at the head of the table. You'll have the petitioner and their supports and their witnesses on one side of the table, the agency, the respondent, their folks on the other side of the table, and you're going to have a conversation. And that's what the root of this is. It's a conversation. The first thing you're going to need to understand is the burden of proof. Made as simple as possible, the burden of proof is which side has to convince the hearing officer that they are correct. For the most part, the burden of proof is going to lie with the agency. The agency needs to make its case that the reduction or termination or denial of the petitioner's services was correct and legally supportable. So they're going to be the people who put on their argument. Oh, excuse me. I apologize. Oh, no. Actually, go back one. 13's good. Yeah. So the agency is going to go first. The way that testimony is going to occur is primarily by introducing witnesses. The agency's representative, who may or may not be an attorney, will introduce witnesses and have a chance to ask those witnesses questions. And as part of that process, may introduce documentary evidence, records, or what have you. During the course of that testimony, you may hear things that you object to or that upset you or that you feel are wrong or misguided. Be patient. Don't interrupt the testimony. Instead, hold on for a moment because you subsequently are going to have a chance to ask that witness questions yourself. And I'll talk a little bit about that process as well as Edie in a few moments. After the agency and its witnesses speak, you will have a chance to do the same thing with your witnesses. The agency will have the same chance to speak with your witnesses as well. And then ultimately, the hearing officer may allow you to do to make some concluding remarks to summarize your case and take care of any other business that needs to be addressed. During this process, do not be afraid of the hearing officer. The hearing officer is there to guide the proceedings, but he's also there to work with you and help you to make your case. Now, he's not going to give you arguments, he or she. He's not going to give you arguments. He's not going to give you suggestions on who you should ask, what you should ask, or who you should ask it to. But he can help you on procedural issues. So if you have a question, don't hesitate to ask the hearing officer. It's not going to go against you. Next slide, please. This is still me. Also, regarding the hearing officer, if you should feel that you are being bullied or that you aren't being allowed to speak or that the agency's representative isn't behaving appropriately towards you, speak to the hearing officer about it. It's okay. Because if he or she agrees with you, they might be able to make you a little bit more comfortable and make the process easier for you. So again, don't be afraid to speak with the hearing officer. They're not against you. They're not biased. They're not there just to turn you down. They're there to make sure all the facts are exposed and they can make an appropriate legal judgment. Next, let's talk briefly about how you can frame your arguments. Again, we're not going to be able to address individual arguments here that are specific to your fact-specific cases. I can't give you legal advice at this point in time. It's just not the right venue. So if you have questions regarding specific elements of your case, if you have an ongoing appeal, please call our intake line and go through our process, and we'll see if we can help you out in that method on a more individual level. The most important thing regarding the arguments you're going to make is that you have to argue the law. It's very tempting to make emotional appeals that this reduction is awful, this reduction is going to do harm, this reduction could hurt the individual, that it's just an unjust and terrible thing. That appeals to me as an individual, as a person, as a human being. I am persuaded by that. But the hearing officer has to base his judgment in the law. As Edie discussed with you earlier on, you need to do research into the law. You need to know what laws affect your position, and you need to be able to argue them. As I said earlier, you need to know who has the burden of proof so you can address your arguments correctly. And you need to ultimately argue facts that you can prove. It's one thing to say, if you do this, if you take away this service, my client or my son or my daughter is going to wind up in an institution. It's another thing to show evidence that elimination of that service through testimony or through documentation will endanger their ability to remain in the community. So please, that's another part of the preparation process. Make sure that any argument you make is supported by evidence. That's critically important. Next page. Actually, I guess last page. Sorry about that. Go back one. Oh, no, okay. Different title. All right, sorry about that. Forward one page. Okay. Just a couple more tips to help frame your argument. Like I said earlier, the agency is probably going to say things that upset you. They're going to say things that may be correct from their perspective, but are clearly wrong from yours. Remain polite and respectful. No matter what the agency does or says, it is always in your benefit to remain polite and remain respectful towards them. Try not to interrupt them. And if anything needs to be addressed to the agency that is outside of testimony, please try and utilize the hearing officer in conveying that. Don't just talk to the agency directly. Also, when you hear the agency make an argument, write it down. Take notes. Taking notes is critically important to being successful at the hearing. And then when it's your turn to speak with their witness or to present your own arguments and your own witnesses, respond directly to that argument. You need to engage them. It's not just an issue of providing your own arguments and walking away. You need to answer theirs as well. So record what they say and then refute it. And like I said, listen carefully to what they say. Take notes. Preparation, 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 and note-taking. That is the key to success here. All right. I think, Edie, you're going to give a couple more specific ideas on how to convey testimony.
Yes, thanks, Brian. And testimony, just as you all understand, I think, from watching so many crime dramas, is what's said at a hearing. And testimony can be given by witnesses. You will be giving testimony when you answer questions or present your argument. And be ready for testimony again, and we keep saying this, but practice, practice, practice. Brian and I and Sylvia are well aware as attorneys that the more you have practiced, the more you have rehearsed, the more you have organized your presentation in any kind of hearing, the easier it is for you. You can go in confident. You can listen to what the other side is saying. Brian's point about taking notes. One of the things in terms of hearings is that though you may be nervous ahead of time, once you get there, if you follow our tips, you're not going to have time to be nervous. You're going to be listening to what they say. You're going to be recording what they say. You're going to be figuring out how you're going to respond to what they say, and then you're going to be presenting your own testimony. So one of the things in terms of specific testimony, moving on to the next section, is that direct testimony needs to be short and it has to be on point. Backward, actually. But, and what that means is when you rehearse your witnesses, when you prepare your information, when you're getting ready to go to this, practice questions. You should never ask a witness a question in a hearing if you don't already know what their answer is. And although that's the goal that you want to go for, you want to be sure that you know ahead of time. If you ask this witness this question, what she or he's going to answer.
Edie, just to clarify, you mean your own witnesses?
Yes, yes.
So in other words, you should chat with your own support coordinator, your own provider, your own treating professional about how they would answer a question, and that way you know in advance how they're going to answer the question. And you ask the question, neither you nor they are surprised you asked it or what the answer was. So as far as preparing our own cases for our family members and whatnot, we don't want to have surprises in our own story. We want to know what the story is, what our own documents say. Now, when you ask the agency's witnesses, theoretically, there shouldn't be surprises either because you've seen all their documents. But I'm sure you're on the spot responses. You want to save those for when the agency says something you didn't expect versus when your own doctor says something you didn't expect. Okay, I think I'm with you now.
But you'll be ahead of you will if you have thoroughly prepared and you've seen what the agency is going to present ahead of time. You've gotten the information through discovery. Then when you ask a question, if you get a surprising answer and it's not what you think it is, you can, after that person testifies, you'll have the opportunity to refute what they say by presenting the evidence that you have that refutes that.
I got a question from an audience member about rebuttal evidence that I actually want to ask you right now. And it has to do with can you present a document in rebuttal that you didn't present in your exhibit exchange?
Do you mind?
Go ahead.
Okay. That's part of, my answer is going to come out of the informal nature of these hearings. If you were both attorneys, my answer would be flatly no. You can't introduce novel evidence at the hearing. But what might happen is that because this is a relatively informal process and because the hearing officer knows that you're not a legal professional, they may, at their discretion, allow you to submit rebuttal evidence that wasn't exchanged prior to the hearing.
Great. Thank you, Brian.
Okay, thanks. And another piece of this in terms of the testimony, you need to prepare your witnesses and yourself so that any answers that you give in this hearing are short, they address the question that was asked, and they're on point. If at any time you need to advise your witnesses of this ahead of time, there's a question that's answered by the agency that you don't understand, or they're asking you and you don't understand, say you don't understand, ask the hearing officer to make the question more specific. You don't have to answer a question that you don't fully get. In fact, take your time. There's no hurry. Just, I don't understand. Could you be more explicit? And again, be sure we have a tendency in these hearings, because as Brian has told you, they're really informal. We're sitting around a table talking. It's a conversation. So when people ask questions, the tendency is, like in a conversation, to give lots of information. Restrain that impulse. You need to just answer the question on point and as short as you can, and don't give any extraneous information. And then again, as Brian already mentioned, you need to be listening. Everything the agency says, any of their representatives, anything that's out there, you need to make notes of it. You need to figure out ahead of time how you're best going to be able to make notes that you can understand. Because some of the things they say, after they've said them, you're going to want to respond to them. So you need to have really organized notes. So figure out how you're going to do that ahead of time. And I think Brian has already told you, but this is it's a hearing, it's informal, but there will be a recording of it made, a transcript. So everything will be on the record. Brian, did you want to add anything to that? Is that
just in brief summary, keep in mind that you will be asking questions of the agency's witnesses. They will also be asking you questions if you choose to testify on your or the individual's behalf, petitioner's behalf. So be prepared for both scenarios. And I think Edie told you exactly how to do that. Be confident. Don't feel harassed. Just go in there prepared and ready to answer questions.
I really appreciate that you have clarified this funny dynamic here, which is it's informal, it's conversational, but it's very important to only answer the question asked. And that's not easy for anyone. So I think that's a really great takeaway from this section on testimony is, you can ask the hearing officer to help get the question clearer. You can ask the question to be more clearly stated. But you've got to just not turn into a geyser of information, and because the hearing officer could get confused if the issues are not kept within the scope of the dispute at the hearing. And I think that's really hard for all of us is to want to go to other denials, other reductions, other terminations, other habits or behavior of the agency. And what I hear you saying is keep it focused on the notice that is in dispute, which is the notice that reduced, terminated, or denied a specific service or device. And don't tell the life story of the individual because you'll lose the focus of the hearing officer.
If I could add just one more point to this, and we've already said it, but in my experience in these hearings, in addition to witnesses wanting to give too much information, the other major thing that I observe, and it's human nature to do it, is to go into the emotional ramifications of what this is going to mean. We're talking about someone's life here, and these services are impacting that life and the quality of life, so it's natural for us to want to bring that in. But if it doesn't affect or address in any way the legal reasons for denying it, it's pretty much irrelevant. And it's really, really hard to make that disjunction between being a human being and then addressing the legal arguments in this case.
I think that's a really great reminder. Two little clarifications we can handle right now through the questions that are coming in. One question that's come in is, do the procedures for these hearings apply to med waiver services? And we just want to get that squarely on the table. Yes, these procedures apply to med waiver services and state plan services. Crossing that question off. Moving on. One more question now, though, about witnesses, because this is a great question. If your witness is not available to attend in person or by phone, do you have any option for submitting their testimony or their evidence in writing?
Yes, and that in terms of the preparation part of it, statement, you'll want something from them anyway if you can on the record, saying who they are and what kind of relationship they have and how whatever they do that supports your argument. You'll want that on the record anyway
As an
exhibit in written form. There's also a possibility of something called an affidavit, which would basically attest to, and you can have them write out exactly what they would probably be saying. The downside to this is you probably need to submit that in advance so that the agency will have a chance to review it, and if they have any questions or they have any rebuttal to it, then your person may not be there to help you respond to it.
Let's just go into briefly circling back to why a continuance might be something appropriate to request and why a hearing officer might give a continuance. This strikes me as one of those fundamental fairness issues. If your witness is not available, would that be a good reason to ask for a continuance?
Absolutely.
Yeah, especially if it's critical witness. Absolutely.
Yes, and that quite often hearing officers routinely grant continuances for exactly that reason.
Because the dynamic you just described of I've got my exhibit and my affidavit, but when the agency brings up an argument against that my witness isn't here to address, that feels like a bad moment in a hearing to me. And so what I hear you saying is rank your witnesses by priority according to, are they treating professionals that prescribed the service? Are they treating professionals that prescribe the device? And if those people are not available because they have conflicts, Sometimes that can be worked out between opposing counsel and the hearing officer, and you should bring that forward early so that the scheduling is fair.
And again, a continuance is just asking to reschedule once you get the hearing thing. So as Sylvia said, organizing your witnesses and knowing which ones are vital for you to be present, and then making sure that they're available for the date of the hearing, and if not just available but able to attend the hearing, willing to attend the hearing. If they're not, then it's when you file for a continuance to ask for the hearing to be
That's
scheduled.
one of the reasons why you file.
Right, thank you.
Can you just name a few other examples of types of witnesses?
Well, I mean, I can name broad categories. As Sylvia has mentioned, treating physicians are an incredibly important one, especially if they've prescribed services. The parents or guardians or caretakers of the individual themselves, if they choose to testify, the waiver support coordinator might be important. Service providers, for example, if your nursing services are being reduced, you might want to have your nurse come to testify as to the importance of those nursing services. It's a very broad thing. Anyone who can provide relevant and on-point information that enhances your arguments is someone you might want to call as a witness. Of course, don't call too many witnesses because you don't want to provide a lot of duplicate, repetitive information, and you don't want to run out of time to provide all of that testimony. So make sure that you know who is important and who isn't.
We're going to wrap up the next few slides and circle back to a few more great questions. How about what happens next, slide 18?
Well, you've gone through this hearing, and it's an ordeal that you've been preparing for months, and you feel fantastic that you've made your way through it. I've got bad news for you. You are not going to get a decision right away. It's unfortunate, but that's how it works. Depending on what agency you're appealing from, and this will become explicit when you get it, you're going to receive either a final order or a recommended order from your hearing officer. That could take anywhere from weeks to months to occur. It really depends on how busy your hearing officer is, what priority your case is, and so on. I can't give you any idea how long it will take. Once you have a recommended order or a final order, you need to read it very carefully. If you have a final order, that's it. You're done for this stage of things. That is the ultimate decision in your case, unless you choose to appeal it, which we'll discuss in a second. If you receive a recommended order, you have the right to submit what are called exceptions. If the hearing officer made a determination of a legal point and you feel that that was done wrong or that his ultimate conclusion was wrong, you can submit an exception to the agency, and the agency will consider whether or not it was correct. Once you've got a recommended order and once you've submitted your exceptions, if you choose to, and let me emphasize, exceptions are not another chance to restate your case. You have to address specific findings of law that the hearing officer made. Once you've done all that, the decision will actually go to the agency that made the determination, and they will issue a final order if you didn't get one previously. So be aware of whether you receive a final order or a recommended order. Look at the title, because that determines whether or not your situation is finished or you need to take further action. Also, during this process between a hearing and a final order, if you filed within 10 days and it was a denial or reduction of a ongoing service, you will still be receiving that service. So keep that in mind. The service only ends if you receive an unfavorable final order. That said, there is one more step, and I'm going to let Edie talk to you about that.
Thanks, Brian. And we're just about at the end of the process now. All that we've talked about so far involves proceedings in the administrative hearing process. So when we initially talked about you get a notice of denial or reduction and you file an appeal or you request an appeal, that appeal is the one that we just talked about that goes through the administrative process. Brian just took you through the final part of it. Let's assume you've gotten a final order and it's not favorable. They're cutting your services. You have a few options. You have a couple of options. One is to do nothing, obviously. The other one is to take it out of the administrative hearing process into the the civil hearing process, which would involve a district court of appeal. you have the right to file an appeal from a final order that's unfavorable to you in either the First District Court of Appeal, which is the one here in Tallahassee that addresses most state agency questions, or if you're not in this area, you can choose your local District Court of Appeal. There are 5 in Florida, and you can choose which one to file at. Be aware, if you take it to this stage, first of all, as we've talked about all throughout this process, deadlines are critically important. In this case, the date the final order is signed, becomes final. From that date, you have 30 days to file an appeal in whichever District Court of Appeal you choose. If you miss that deadline, you usually cannot proceed with an appeal, number one. Number two, when you file the appeal, there's a strong possibility you're going to have to pay a filing fee, and there's also, as Brian said, your services are likely to be discontinued if you had an unfavorable order. So, one thing, if you're going to pursue an appeal like this to the District Court of Appeal, you feel very strongly that you have a case and that it was wrongly decided, and you feel like the law is in your favor, then you have the right certainly to pursue an appeal. It's not an easy process taking it to an appellate court. I would strongly suggest you try and obtain an attorney to help you with this. The appellate process is not easy. If you want to try and do it on your own, and again, the administrative hearing process is designed to be layperson friendly. It's designed to be something that you don't need an attorney to go through. All the hearing officers are aware of that. This type of appeal, the next level, taking it to a District Court of Appeal, is not layperson friendly. Essentially, you need an attorney or to consult an attorney to go through this. If you want to try it on your own, the only suggestion I can make is contact the clerk at whichever District Court of Appeal you're going to be filing at. In all cases, in the administrative as well as this, the clerks of the courts or the administrative hearings are extremely excellent resources, and if they're helpful, favorable, they can give you a lot of favorable information. But just to wrap this up, in terms of the appeals, there's lots more specifics about this in our Advocacy 101 manual, number one. Number two, if you've gotten a a final order unfavorable to what you had argued for, and you strongly believe you have a case, feel free to do an intake with Disability Rights Florida and ask us to review it. Be sure and do it within the time frame as soon as you get the final order, essentially. And if we'll review it and see if there's anything we can do to assist you with. Is there anything?
I have a question in this area because I was really glad that you clarified that both the hearing officer, the trial in front of the hearing officer, the informal trial with the witnesses and the exhibits and the arguments, is called an appeal. And then when you lose and you go to a court, not an administrative hearing but a court, it's also called an appeal. Naturally, we got a couple of questions about that through our question and answer email address. It's a little confusing for people to deal with those labels. What else do they call the trial down below? Do they call that? I've heard that also called a hearing. I've heard it called administrative hearing. Right. I guess what we want to try to teach people is, you're at the fact presenting part of it if you're in front of a hearing officer. Is that a fair summary?
Yeah.
And there's one other piece. Excuse me, I didn't add this. I'm sorry. The one, this is critical in terms of the appeal. I left it out, and it is that after you get the final order, if you do decide to take it to an appellate court, a District Court of Appeal, everything that goes into the appeal has to be based on the information that was presented at the hearing. So anything happening after that, subsequent to it, that affects your case, you may have gotten a new doctor who's got something that looks like really solidify your argument for getting these services. You can't present that at the appeal. You're bound by, in this stage of the appeal, everything that happened up to the hearing. And I'm sorry I traveled on you, Brian. Go ahead.
Here's the easiest way to sum it up. The administrative appeal is the first step. At that point, you are appealing the decision made by the agency. The next step is a DCA, District Court of Appeal. At that point, you are no longer appealing the decision made by an agency. You are appealing the decision made by the hearing officer.
Great.
That is the critical summation.
I think that's super helpful. Couple of related questions just to get them on the table right now. Between the time you ask for your hearing to dispute the decision of the agency and when the hearing will be held, how long is that typically?
It's extremely variable.
Okay. Thank you.
I wish I could give a better answer.
And it's fair to say that that's affected by the hearing officer's schedule, your schedule, and the agency's schedule, and the amount of workload that the hearing officer has. If a person has questions about that, that's a great question for the clerk who's supporting that hearing officer, because it's just a procedural question that the clerks have a handle on and the ability to answer for a family member. Would you agree?
Mm-hmm.
Okay, great. Let's take it through the last couple slides, and then we'll do the rest of these great questions. We have about 15 more minutes, and I think we still have 100 or so people with us on the phone.
Great. All right, let me give a super brief conclusion here. You're going to get a notice. That notice is critically important. Read the notice. The reasons given for the denial in that notice are going to frame all of your preparation and all of your arguments at the hearing. So make sure that you're familiar with them. Then begin to prepare. Put together information and put together arguments that address the reasons given in the notice. Develop evidence, develop testimony with witnesses. Take that into the hearing. Be confident in the hearing. Go into the hearing prepared. Address the agency's arguments and try to limit what you're addressing to the agency's arguments, both in the notice and the arguments that they make at hearing. At that point, wait till you get a recommended order and issue exceptions if necessary. If not, you've got your final order and you can move into the District Court of Appeal if you feel it's appropriate. These administrative hearings are meant to accommodate non-lawyers. Do not be intimidated. They are intentionally designed to work with you as a layperson, assuming I'm not talking to an audience of lawyers right now. The key to being confident is good preparation and organization. We cannot emphasize that enough. Do not wait until the week before your hearing to start preparing. You will lose. You have to prepare early and you have to prepare well. Focus on what matters most. And what matters most are the arguments that the agency is making. Don't let yourself go down rabbit holes. Don't let yourself get distracted. Find out what their argument is, and that should be framed in the notice, and address it as well as you can. If you can master all of those steps, and if you can do all of those things, you stand a good chance, if the law is behind you, of winning your hearing. This is not an impossible thing. These are not stacked against you. You just have to know how to prepare, and you can be very successful.
Thank you both, Edie and Brian. I certainly thought that you did a great job taking a complicated situation and making it as simple as possible. We've got a few more great questions and still a lot of people on the line with us, so let's go through a few more questions. What happens, or what is your suggestion for an individual who goes into a situation prepared but they thought it would be more informal, and what they encounter is a large number of attorneys and representatives from the agency, and it really throws them, and they wish they had more help in the room? Can they ask that to be rescheduled or continuance at that time, or would you just recommend that people plan to take someone with them? How do you handle this?
Well, two answers to that. First question, you can always ask. Even at the hearing, you can ask to have it rescheduled. However, I would not count on that. Chances are the hearing officer is not going to grant that continuance, and it is totally up to the hearing officer, so you'll probably have to go forward. In terms of bringing people to the hearing, you're welcome to bring people to the hearing. Even if they aren't your witnesses, even if they're just another individual you want to have help you make arguments, you're certainly entitled to bring them to the hearing to support you. Edie?
Well, I was going to add in terms of your first answer, Brian, and I agree with all that you said, but as we've already pointed out several times, the hearing officers in these hearings are very well aware that they have lay people involved in doing them, and they're often very well aware that the agency may have an attorney or attorneys involved, and they are attuned to, in my experience, fairness. And so if you truly feel, if you go into a hearing and it's just you, let's hope it's not, but it's just you, and there's a bank of attorneys across from you representing the agency, I would say certainly just ask the hearing officer in fairness to continue it, to allow you to possibly obtain legal assistance.
It never hurts to ask.
Exactly.
Right.
And that's the bottom line. It never hurts to ask the hearing officer to accommodate your needs. Now, if you are denied that request, you have to go forward, but you have possibly created an issue for appeal. So it's worth asking, even if you're worried that you're going to be denied.
And the second part of Brian's answer, excuse me, in terms of bringing someone with you, that's usually very well advised to have someone there, even if they're just to support you. It really makes a difference if you have someone who is a second set of eyes and ears, and they can alert you to some of the things that you might have missed going on. So, and you are certainly, it's certainly okay for you to bring someone.
Now, here's the bottom line, and a couple questions have related to this. Just for that last slide, Keith, if you could put the last slide up and leave it. We have just presented, a fairly sophisticated challenge for self-advocacy, and we know that. We've tried to write about it on our website. We've published a booklet about it that's on our website. We'll probably be doing subsequent webinars about it like this one, especially now that we've learned some major lessons about the technology, and you have been incredibly patient with us in that regard. Thank you. But the bottom line is sometimes a challenge of this nature is beyond the comfort level of a family and the individual. Several people have asked, do we recommend an attorney? Other people have asked, what are our services? So I would just like, Brian, if you could just address whether we recommend an attorney and what are our services. I think that's crucial.
Sure. In terms of whether or not we recommend an attorney, the fact of the matter is that it is always going to be empowering to have an attorney who is familiar with these issues with you. If you have the choice between having an attorney and not having an attorney, you probably should not kick the attorney to the curb. That being said, there is a limited pool of resources, both individually amongst yourselves and amongst the attorneys who are familiar with these cases and work with our stakeholder groups. So it is not universal that an attorney may be available. It doesn't hurt to ask, and it certainly doesn't hurt to request our services. But ultimately, unfortunately, just due to resource issues, we cannot take every case that comes to us.
There's a few sources available in some local communities through legal services, and we tend to know where those legal services offices are that have experts in Medicaid. Many of them do.
Yeah.
And that's an option for some families based on income and assets. We offer some technical assistance to some families when we can't commit to actually doing the full representation. So we triage the risk to the individual, the skill level of the advocate and the family member to determine how we can utilize our resources the best. But certainly calling us early to review even just some procedural questions you might have is a great idea. It's not necessary. In other words, we can provide assistance even if we can't be there with you in the hearing, and we can't be with everybody in every hearing, and that's the problem and the reason why we're doing webinars like this. Everybody good with that answer?
Mm-hmm.
Okay.
Yeah.
Just a couple more questions. We've got about 5 more minutes. What happens if you no longer need, what should you do if you no longer need the hearing that you asked for?
You should contact, oh, I'm sorry, I didn't mean to interrupt you.
Go ahead.
You should contact the hearing officer and tell them so, and they will dismiss or cancel the hearing for you.
So that's just a good courtesy to get it off the books.
Yes.
And yes, so you can send a letter or make a phone call telling them it's no longer needed.
And that the contact information you'll need will be included in the notice that sets the date for your hearing. If you haven't gotten that notice yet, you'll want to contact the agency whether it be APD or ACA, and request a cancellation with them.
When you ask for discovery, how do you know what state agency or what entity to ask for the discovery?
It depends on the agency, whichever one has denied or proposing to deny or reduce your services is the agency who has the whole file. So that's the agency that you contact. And again, that denial notice that you get, the notice that you get gives you information about where to send your request for discovery.
Right. This is going to sound like kind of a snappy answer, but check the letterhead for your notice. It will generally list the agency that you're receiving it from.
And that's important because a lot of people receive services from ACA and APD, and it can be a little confusing who is the entity that's denied you. And the best thing to do is literally just look at the notice very, very carefully. It will probably tell you what you need to know. We've got a few more minutes. I'm just looking over the questions that are coming in to see if there's any more we want to take. There was a question asking us to clarify the rebuttal information, so I'm going to clarify that because what I heard us say is that you do have the right to present rebuttal evidence. So I just want to clarify that we believe you do have the right to present rebuttal evidence, even if it wasn't exchanged during discovery. It will probably be admitted.
I would not say you have the right, but otherwise it would probably be.
Here's one more situation I think does occur frequently. What happens if your individual's medical situation worsens after the hearing, but before the final order?
That goes back to for additional services.
Yeah. I think Edie's correct in her suggestion. At that point, unfortunately, that's not going to be information that's relevant to your current appeal. But what I would suggest you do is that you gather more information to support the worsening condition and request additional services with the agency. And that will start a whole new process for you.
If I could add just on a totally unrelated note, and again, I'm plugging the Advocacy 101 e-manual that we have on our website. In the back of that, there are sample forms for you to use, and one of those includes a sample motion for continuance, which we tried to make it easy if you needed to ask for a continuance of the hearing.
But don't feel like you have to use a legal form for that, as long as you communicate it adequately.
So Brian is indicating that he wants to revisit the question of the rebuttal evidence as a right. So the person that asked that question is a pretty knowledgeable individual, and that person, we will get back to you directly. They've sent us an actual rule of administrative procedure that they think establishes that right. So, this is like you've walked into a little debate between advocates, and that's not that easy to deal with, but it happens. And interpretation and enforcement is something that we are constantly wrestling with. Which brings us to some questions about the I-budget. We can't end this call without some questions about the I-budget. There haven't been very many, but do you have anything about the process issues around I-budget that you just want to share with the audience generally?
Well, let me, do you mind?
Please.
Let me preface this by saying that, to the best of my knowledge, none of our staff here at Disability Rights Florida have yet proceeded to an administrative hearing on an I-budget issue. Not because we aren't handling any, but rather because the agency has been kind of slow in referring these to the Office of Appeal hearings at this point. So we don't have a lot of first-hand knowledge about how these are going to proceed. That said, the same rules of procedure that we've discussed so far in this webinar should still apply. And certainly the overarching information about preparation and witnesses and testimony absolutely should. So it's difficult for me to give you specific advice on how I-budget issues are going to proceed, but I think that most of what we said here should be applicable when we start seeing those cases.
Okay, one last question and we're going to wrap it up. If the agency does not send a request to you for discovery, do you have to send them your exhibits?
You should. It's a matter of courtesy. They expect to be prepared for the arguments you're raising. generally speaking, and I'm not sure that we covered this exactly when we were discussing it, before the hearing, and the sooner the better certainly, you should make copies of every piece of evidence you're going to present. And you should make sure that both the hearing officer and the agency have copies of that evidence. That way, when you're discussing it, they have something to refer to at the hearing. That way, they're prepared to address it, and they can address it effectively at the hearing. It makes the evidence more valuable.
It also might be problematic if you get to the hearing and you haven't presented your evidence ahead of time, as Brian talked about earlier, in terms of presenting it's considered new evidence. If the hearing officer hasn't gotten it, and also the agency, it's considered new evidence at the hearing, and it might be, may or may not be admitted. So, of course, submit yours to the agency.
And we have a whole chapter in our ebook on discovery, if I'm not mistaken. That's a very crucial segment. I want to thank Brian and Edie and our IT expert, Keith Caspon, and our audience. We want to thank you for joining us, because by trying to learn how to exercise these procedures with more effectiveness and more confidence, you're helping raise the capacity in the community at large with regards to people with disabilities and their rights and responsibilities being honored and fully exercised in the administrative hearing process, whether it's with ACA or APD. You'll see a survey when you exit the webinar. We appreciate your candid response. We, again, thank you for getting the word out and joining us today. And with that, goodbye. Thank you.
Bye.
Bye.